Season's greetings, everyone. To celebrate Littleton winning Sports Law Set of the Year, we thought we'd do a roundup of some of the biggest and most important sports law cases of the last 12 months. Thanks for your support this year, and see you in 2024. We hope you enjoy.
Well, the incident I want to highlight from the last year is the extraordinary episode of Match of the Day that was aired in March 2023. At only 20 minutes, it was entirely clips and highlights from the games with no commentary from the star-studded team. Why? Well, Gary Lineker had been suspended for his comments on Twitter criticising the government's policy on asylum seekers. And his fellow pundits had refused to go on air while he remained suspended. And what this whole incident really highlighted is not only the power of sports personalities, but also the reach of sport into areas far beyond its natural remit. And finally, the limits on what an employer can do to control what the employees say in their own private social media accounts.
Perhaps the most dramatic moment in sports law in 2023 came on the 17th of November when a Premier League Commission deducted 10 points from Everton Football Club. Everton had been charged with breaching the league's profitability and sustainability rules, a breach which the club eventually admitted. The hearing was to determine the extent of the breach and any appropriate sanction. Now, in making its decision, the Commission made a number of stark findings. First, that the core objective of the rules was to ensure that clubs operate within their financial means. Second, that the Commission had unrestricted powers within the rules to determine an appropriate sanction. And third, that the starting point when considering sanction is to consider the need for punishment. A number of aggravating and mitigating factors were advanced. Notably, the club was found to have breached the duty of utmost good faith, notwithstanding, interestingly, that it had been found to have engaged extensively with the league before and during the process. What will be the fallout of this case? Will other clubs now decide to sue Everton for compensation? Well, a preliminary ruling in the case itself has opened the door to that. We'll have to wait and see. But what's for sure is that Everton have appealed against the decision, and that is intended to be completed by the end of the current football season. So plenty to watch out for in 2024.
Rugby's a contact sport, but what it is increasingly over the last few years is an impact sport. And what we've seen is the rise of the prospect of litigation. And what I want to talk about is the group action in connection with concussion-related claims, which is now presently being brought against the rugby football unions of England and Wales, and also rugby league, and to a smaller extent football. So very recently, the step of creating a class action and seeking a group case order in the High Court has progressed for approximately 300 cases presently being brought for rugby union players who claim that they have been the subject of concussion-related injuries and bring a negligence claim against the rugby unions of Wales and England, alleging that there was failure on their part to recognise at an appropriate level the risks and take steps in relation to the rules and warning of risks to avoid the injuries which they sustained. Now, this is going to be very important litigation, clearly. We've seen it increase in its scope. Very recently, Colin Jarvis and Gavin Henson, two well-known former Welsh internationals, have joined the group action. The actual order for a group action is not, in fact, now going to be resolved until the beginning of next year. Practically, if this case ever goes to trial, it probably means we're not going to see a trial before 2025, 2026. But it's clearly going to raise important prospects for the future regulation of rugby and indeed football in the prospects of claims related to head injuries consequent upon the sport.
The subject I have chosen from 2023 is the Netball Australia dispute. So just to give you a brief background into the dispute, the governing body of Australia's domestic netball league, Netball Australia, have not paid their players since September, which is when the collective player agreement expired. Now, the Netballers Union, the Australian Netball Players Association, have been in negotiations with the main issue being on revenue share model. Now, last Wednesday, Netball Australia did give an interim offer which was rejected by the players. There have been rumours that an agreement has now been reached following talks last Friday, but nothing has been publicly confirmed yet. Who knows, by the time you're watching this, something may have come out and it may have been confirmed. But in the meantime, I think there are three main takeaways from this pay dispute. Firstly, the power of unity. The players are collectively standing together in order to fight for better terms and conditions. A big bargaining tool for them is that not reaching an agreement was having a big impact on the future of their sport. The teams could not be agreed and individual contracts could not be played for the 2024 season. Secondly, it's how the bigger financial picture affects a governing body's ability to negotiate. Netball Australia has openly had financial troubles following COVID-19 and has recently lost public funding. I'm sure those things factored into their considerations throughout this negotiation. Lastly, and perhaps most importantly, it's how negotiations can sour relationships. I'm sure the last 8 weeks have been a long 8 weeks for all involved, and that this dispute has likely affected the trust between the players and the governing body. In such circumstances, it will be interesting to see how the future of the league will develop and hopefully prosper.
All right, my sports law highlight of 2023 is actually something that hasn't even happened yet. So I am in that sense the ghost of Christmas future. And what I'm talking about is something that's going to happen on the 21st of December this year, which is the ECJ giving its decision in the European Super League litigation. Impossible to believe that in fact all of that Super League stuff kicked off 2.5 years ago in April of 2021 when six UK clubs and a load of European clubs decided they were going to set up their own league, causing the biggest football controversy we've had in a very long time. What they're complaining about, the Super League, to the European Court of Justice is that the UEFA rules, which require permission before you can set up a club competition, are a breach of European competition law. And even before they'd asked UEFA, no doubt knowing what the answer was going to be, they started litigation in the Spanish courts, which eventually went to a hearing in July 2022, so nearly a year and a half ago. We got the Advocate General's opinion supporting UEFA in December of 2022, and it's taken a whole other year now to get to the European Court of Justice giving a final view on it. Now, given that the Advocate General was on the UEFA side, given that the Commission and 23 EU member states were on UEFA's side, I think I can probably guess how it's going to go. But if it doesn't go that way, it's going to be one of the most momentous moments in football I can remember.
Forget about the Euros. By far the biggest fixture next year is going to be the Premier League against Man City, the fair play arbitration now set for autumn 2024. There are 115 charges infamously, but actually it comes down to a handful of allegations. And by far the most important of those in terms of the amounts involved is the allegation of disguised equity funding relating to sponsorship deals with Etihad and the telecommunications company Etisalat. Now, of course, in football, it's a far bigger sin to be over-investing in a club rather than under-investing, as the Red Heart of Manchester can attest. In this case, the allegation is that there was very substantial over-investing in relation to the Etihad deal, with most of the 220 million sponsorship coming from the owners. That was rejected by CAS, but the Premier League want to have their own swing at it, and so there may be allegations as to abusive process in them doing that, and that'll have to be tested. The other allegations in relation to Etisalat, smaller amounts, about 30 million, but they weren't dealt with on the merits. They failed in front of CAS on the basis of time limits. The other two allegations both arise from leaks in Der Spiegel in 2022. One relates to Manager remuneration payments over 4 years of £1.75 million a year alleged to have been made to Roberto Mancini's company. The other, about €8 million, said to have been made to Yaya Touré's agent's company. So smaller fries, but significant issues nevertheless. And then the final points relate to non-cooperation, which is alleged from December 8, 2018. That couldn't have led to a sporting advantage. So it's the other allegations that can lead to sporting sanctions such as expulsion or claims by other clubs. And it's those other allegations which is going to decide whether we City fans get to relive the not so halcyon days of York City away, this time in the National League.
I'm going to talk about the cases between England and Wales Cricket Board, Yorkshire County Cricket Club and a number of ex-players. The genesis of these cases was the disclosures of discrimination made by ex-players, the most high profile being Azeem Rafiq. On the back of these disclosures, the ECB charged Yorkshire County Cricket Club, Michael Vaughan, Tim Bresnan, Matthew Hoggard, Andrew Pyatt and Richard Gale. The charges brought by the ECB against the respondents was all the same. According to the ECB, the respondents had conducted themselves in a manner or did an act which was prejudicial to the interests of cricket or brought the game of cricket and cricketers into disrepute. These cases were heard by the disciplinary panel of the Cricket Discipline Commission. The CDC is the body that hears disciplinary matters in the game of cricket, the professional game of cricket, and when it hears these matters, it normally sits in private. These cases were of interest to cricketers and sports lawyers alike, as it shone a spotlight on the culture of the game. The respondents included some very big names, and contrary to their usual custom, the CDC decided to hear the matter in public, and so we all knew exactly what was going on.
The subject I've chosen for 2023 is Caster Semenya's European Court of Human Rights case. Semenya first brought a challenge against World Athletics' testosterone rules before the Court of Arbitration for Sport in 2018. In May 2019, she lost her case, but that was not the end. She next appealed to the Swiss Federal Supreme Court, where her case was rejected in September 2020. This took her to the European Court of Human Rights, where in July 23 it was held that her rights under the European Convention on Human Rights had been violated. This ruling, however, did not strike down the rules, and World Athletics said soon after the judgment was released that the contentious testosterone rules would remain in place. What the European Court of Human Rights decision did do is it opened the way for the Swiss Federal Supreme Court to reconsider its decision. That might result in the case going back to the Court of Arbitration for Sport. Only then might the contentious rules enforced by World Athletics possibly be removed. However, before this can happen, the case will be heard by the European Court of Human Rights' Grand Chamber for a final ruling following the referral request from the Swiss government. This announcement was made in November 2023. The future of Semenya's athletics career, and that of many other athletes, is therefore still left uncertain. It will, however, be fascinating to see what happens at the next stage of this contentious issue.
FIFA approved the FFAR, the FIFA Football Wages Regulations, in December 2022, with parts of the regulation to be rolled out across 2023. Announcement of the regulation was met with, of course, some consternation from agents and also agents' associations. When new regulations are implemented, there is always going to be pushback from the old guard because of the new obstacles and the new challenges that the regulations bring to those to whom it applies. In this case, Article 15.2 was of concern. It capped fees to 3% of players' contracted salaries, or 6% if the agent was representing the player and the club. The cap increased to 5% if the player being represented had a salary of $200,000 or less. The real complaint is, of course, that money was being taken from agents' pockets, but the case pursued on much more technical legal bases. Before CAS, the Professional Agents Association brought several arguments, which can be summarised broadly under two headings. The first was that the regulations were anti-competitive in and of themselves. The CAS didn't like that argument very much. It found that below the cap, competition could still take place, And the cap wasn't the be-all and end-all. Agents offer and could charge uncapped various other services to clubs and players. The second was that those agents operating at the 5% cap wouldn't be able to compete with those agents that were operating at the 3% cap. Now, it's clear that 3% is more than 5%, but 5% of $200,000 is much less than 3% of $200 million. And so one can perhaps see the force in their argument. CAS didn't like it. It didn't find that there was any reason or indeed evidence to believe that pre-cap there was competition between those smaller agents and their firms and the larger agents and their firms. So where does it leave us? Well, elsewhere in Europe there have been early warning signs as to the life expectancy of the football agents regulations and indeed the soundness of CAS rulings. We already have an interim suspension in Germany and also in Spain of the regulations, with a decision to be given by the European Court of Justice probably next year or maybe even the year after. Here in the UK and in England in particular, there's been a successful challenge in the Wasserman case against the implementation of the regulations. And so it seems that as we approach the new year, the ball is being shifted squarely into FIFA's court.
The worlds of sport and betting have always been intertwined, but in 2023 we saw two high-profile examples of them coming together in a way which cost two well-known footballers and their clubs. The first high-profile case was that involving Ivan Toney, Brentford striker, who was charged by the FA with a substantial number of breaches of the FA's betting rules. All told, Toney admitted to 232 breaches over 5 seasons of Rule 8 of the FA rules, which is the prohibition on betting on football by a participant. Whereas the charges were admitted and therefore the disciplinary commission was only dealing with sanction, the written decision of the commission in suspending Toney for 8 months is interesting for its navigation of various factual disputes which arose within the context of the argument about sanction itself. Most notable, perhaps, is the weight that was placed evidently by the Commission on the expert evidence of a consultant psychiatrist on behalf of the player, who opined on gambling addiction and whose evidence was described by the panel as providing significant mitigation. Toney is scheduled to resume playing in the new year. The second high-profile betting case this year was that of an Italian international, Sandro Tonali, whose case was truly international in scope, spanning the Italian FA, the Italian League, an Italian club, the English FA, an English Premier League club, and FIFA. The case was brought by the Italian FA following a number of breaches by Tonali of its betting rules. The Italian FA imposed an 18-month ban with 8 months suspended, leaving a ban of 10 months, which takes Tonali out of the season more or less in its entirety. Particularly interesting is the international element in this case. So whereas Tonali, by the time of the ban, was not even playing in Italy anymore, the Italian FA successfully requested for FIFA to make his ban worldwide in effect, which means that despite him not playing in Italy anymore, he can't play for Newcastle or indeed the Italian national team until the ban comes to an end. Whether Newcastle decide in this instance to pursue their own legal proceedings in respect of what may or may not have been known about the player's betting addiction in advance of the transfer remains to be seen.
We hope you enjoyed that whistle-stop tour of the top sports law cases from 2023. On behalf of all of us at the Littleton Sports Law Group, we wish you a very Merry Christmas and a happy and prosperous New Year. We look forward to seeing you in 2024 as we see what the world of sports law has in store for us all.